All right, guys, episode 11. We have our favorite attorney back, Lior. This week, we're going to go over some potential legislation changes regarding COVID, as well as the importance of communicating with your adjuster and your attorney. And finally, take the time to accurately fill out your forms. So let's get to it. Lior,
John,
what's up, man?
how's it going?
Episode 11. Thanks for being back. I appreciate it, dude.
Absolutely.
Yeah. So since we last spoke, things have progressed a little bit. There's been some law changes in regards to COVID. When we last spoke, you talked about claims automatically being accepted under COVID. At that time, we didn't know if they would be calculated into the XMOD, and thank God they're not. So for all of you guys out there, any COVID-related claims that you're having, even if half your workforce went down, this will have zero impact on your XMOD, which is great news.
Yeah, that's a collective sigh of relief for every employer in the state.
It would have taken legitimately probably 20% of our companies, our clients down. Because if you think about it, those claims are all inside their primary threshold, which is the portion that actually hurts their XMOD. And those claims can be anywhere from, 10. And we had one prospect we're talking to had 5 folks pass away from it. And those death claims are $375,000. So, right there, it'd be, you're out of business.
Yeah.
So, thankfully, it didn't happen. But since then, I know there's some new legislation that you wanted to talk about. So, maybe you could fill us in on what's been going on that end?
Yeah. When I was last on, we had discussed N6220, which was the governor's emergency, cobbled together, very poorly written response to COVID-19. And it essentially imposed almost unreasonable burdens on employers by making every single employee have a presumption of having developed COVID at the workplace when, of course, they're performing work at the direction of the employer at the work at the place of employment, which, as we discussed, is very amorphous.
Sure.
But what's important is that had a sunset of only to July 5th, 2020, and the belief was, okay, the legislature is going to get back together and they're going to pass a new law. So there were 3 different bills that were circulating around Sacramento, and as of just last month, or I believe it was maybe earlier this week, whatever, it's very close by. Essentially, SB 1159 is what we're left with. And SB 1159 is now in front of the governor, and he has until almost the end of the month to sign it into law or not. So we will see, that's until September 30th. So he has until the end of the month to sign it into law, and it essentially enshrines the existing framework that the governor made, but only for those claims that are through July 5th, 2020. But moving forward, there will be some significant changes. Now, because it's not passed into law yet, I feel like I don't want to get too much into the weeds on what the play-by-play is, but...
Before you go any further,
Sure.
Before we don't know if it's going to go into law yet, this is passed through every single channel it needs to, and now it's just on the governor's desk?
The House and the Senate, exactly.
Okay, so if this doesn't go through, do they have a backup plan? Because I know you said there's 2 other ones.
No,
Or they just get
I mean,
reworked?
if this gets nixed, or oftentimes, maybe the governor will at least provide some guidance as to why he vetoed it, and then they can go back and make some edits. Because if you actually look at the versions that passed the various houses, there were minor tweaks made between them. So it wasn't like this was unanimous, and there were a lot of different ways that this could have gone. But the positive news that I did want to briefly get into is, as right off the bat, it will no longer apply to everybody. That presumption will go back to the individuals that everyone, all the reasonable, individuals and employers believed at the front, at the beginning of this should be, which are first responders, policemen, firefighters, and similar classes of government employees, as well as first-line healthcare workers who are doing direct patient care. So that would include somebody who's also working in somebody's home, doing in-home health aid.
That seems
type
reasonable.
Services. Yeah,
That seems like a reasonable, move away from where everybody contracted in the workplace. That's great news.
And on top of that, the prior presumption just didn't provide enough enough weight to the simple fact that people are going to markets, some people aren't following social distancing and seeing their friends, and then suddenly, as long as they worked, at a job site within 14 days, now they have this presumption in their favor, regardless of what they've been doing, because of how difficult it is to overcome these presumptions. Now, they won't have it, and not only that, but for everyone else, there will be a presumption of this compensability that happened in the workplace, but only when you reach the threshold within that workplace in a 14-day period of a legal outbreak. An outbreak is the word that is being used in this bill. So an outbreak is when you have 100 employees or less that you have had 4 positive COVID tests from employees within 14 days, within any 14 calendar day period. And if there are more than 100, then it's 4% of the employee base that has to test positive.
So is there any onus put on like these employers to actually test their employees? And was this creating a disincentive to do that?
No, there are actually extremely strict reporting requirements that are going to go into effect. So it's kind of a mixed bag on this one, and that's why I think we're definitely going to need a whole episode, assuming it passes, to come back and really work through some of the minutia, because the reporting requirements are really onerous, and they are on the employer, and there are penalties involved if you don't follow them. So we get the carrot, but then we're also getting a real big stick.
Sure, that makes sense. So since those claims have come in, have you guys dealt with any of those COVID-related claims? And how did those go?
Yeah. I would say an overwhelming majority of the claims are actually working the way that you would expect them to, which is you develop an illness, you recover from it, you go back to work, you get essentially cleared by a physician, and then you return to the workplace. You're not symptomatic, you're not getting anybody sick, great, and you're essentially just getting your time off. If you're able to work from home remotely, then assuming you're able to work while you have the virus, then that would affect very little.
Gotcha. So these haven't been massive claims.
Exactly. Generally, the system works.
Okay.
But there are exceptions, and I would say the primary claims that we're getting on the litigated side into my office are the death claims and the major aggravation of pre-existing lung-related pulmonary diseases, emphysema, people who maybe already have, are immunocompromised. These kind of more chronic and complicated cases are coming in, but most of them are being handled in-house at the adjuster level.
Gotcha. And so this is probably adjacent to your expertise, but is there any civil cases coming from this?
Civil exposure cases, yeah, I would definitely defer to a civil attorney, because assuming it's contracted by an employee at a workplace, that's within the purview of the Workers' Compensation Board. I could maybe see an independent contractor, arguing that somehow he was unduly exposed, but once again, they'd probably be trying to get into the workers' comp realm. So I really couldn't speak to civil.
That's what I'd be curious about. Is like if the employer didn't provide adequate protection, like is there a lawsuit available?
Arguably, so there's a thing called a serious and willful suit that you can bring in the work comp system, and that is when an employer essentially exposes the employee to a level of gross negligence that is so obscene.
Of work comp.
Exactly. And on the flip side, when an employee is acting completely grossly negligent, then actually the employer and the defendant can bring that same cause of action to try to reduce benefits.
Got it.
But that would be an interesting aspect of litigation that I definitely foresee. There are some California applicants' attorneys eagerly waiting to dig their teeth into, and you didn't provide proper PPP, so now every single claim is a serious and willful, and we want a bump on benefits and attorney fees, and
that is going to be a nightmare. I can't imagine. There was probably a bunch of attorneys just chomping at the bit as soon as this happened. Like, oh, we know where this is going.
Every disaster is an opportunity for an attorney to make some money.
Yeah, absolutely. Good for you guys. Yeah. Well, cool. That's good information. I guess we're going to wait and see. Yeah. September 30th?
Exactly. We'll see what the governor does. I mean, as is, frankly, it's, it still puts a lot of the onus in the burden of the employers, but just the fact that we've scaled back that presumption for everyone. And like I said, so the presumption still applies if you were already grandfathered in, but it's more a matter of moving forward from July 6, 2020 is when this new regime would come into place.
Got it. That makes sense. So some of the other stuff you wanted to talk about was the documents, which you've actually helped craft, or your team has, that we have available for our clients. So that's a portion of what you want to talk about. I don't know exactly where you want to start in this.
Yeah, I mean, let's start at the beginning.
Okay,
let's
that's a great place to start.
Actually, no. Where you start with is working with the whiteboard guys on mitigating all the exposures and risks at your workplace and being sure you're engaging in safe practices. But
that's a wrap, guys. All right, thank you.
But no, where the case begins for me and for the insurance adjuster is after an injury occurs.
Sure.
And I'm sure you hear this all the time about employers wanting to be more involved and wanting to mitigate the, claims of injuries at their workplace. And it's one of those situations where a very large lion's share of the work is done on the adjuster and attorney side. But where there is opportunity for the employer, it just makes their participation that much more important. And
Sure.
it's really primarily at the front end on making sure that proper information that can only come from the employer is provided right at the outset of the case, which I'm going to describe. So the first thing that I brought is this is a Department of Industrial Relations form that needs to be filled out on every single claim by the employer. And it's the employer's report of occupational injury or illness. It's a standard form, and it has a whole host of important criteria which should be filled out. And while it may look daunting just because of how many boxes there are to fill, as you start to go through the individual boxes, it's really mostly straightforward up or down type of information that really should be provided. The firm name, etc. So what I've done today is I've prepared just a sample employer's first report, so we can kind of go through it together and just work through what would be an example of how you would fill out one of these forms. So we're going to have a fictitious business that I've created called Alex Tacos Food Truck in honor of this fantastic food truck that parks near my house that I go to far too often. And
Is it Alex's food truck?
Yeah, I mean,
They know what it's about?
I've never met an Alex, but
Yeah.
the food is just phenomenal.
That's awesome.
So we're going to use Alex Food Truck, and as you can see, so fine, that's the firm name. You're going to put your insurance policy, standard information. You're going to put your mailing address, your phone number, the location where you're operating out of, not necessarily the location where the injury occurred. Because, for example, a business may have a mailing address of corporate headquarters, but they are actually operating out of a different office.
Sure.
Then the nature of the business, in this case, it's Delicious Tacos because that's what they're about. They're just about killing it. Then we can move on to some other stuff. The date of injury, very straightforward. What is the date on when the injury occurred? In this case, we're just going to pretend that it occurred on September 1st, 2020. Now, as far as cumulative trauma claims, as we know, very often these are filed post-termination, and it is for a series of employment as opposed to just a specific day where something occurred. So for the date of onset of the illness, typically you just want to put the end date of that cumulative trauma claim, because usually they're going to put it's from X date until X date, and you're going to put that end date on.
So that would be if 98% of CT claims are post-term? Maybe something like that?
It's definitely hard math. Yeah, it's facts.
So that would be their last day of employment?
No, it would be the end date of what they are claiming.
Okay.
Exactly, because sometimes they actually either pick a day that's before the end date of their employment or after, but it's more important that we be sure that we're talking about the same injury. So it's not necessarily like, even if you dispute that anything occurred on September 1st, 2020, or if it's a post-term CT, and even if you're saying that the end date shouldn't be May 30th, 2020 because I fired him on May 27th, if that documentation or the employer is claiming it happened on May 30th, just put May 30th, and that's something that'll be handled on the back end. Then let's just skip straight to 11. This is a question essentially on whether or not the injured worker, because of that injury, was able to return to work. So if they're injured on the 1st and then on the 2nd, they come right back to work, you're going to check the no box because we sent him to a quick clinic, he got checked out, or one of your EMTs came, checked him out, but everything is first aid only, and he's going to go back full duty. Fantastic. So that would be a no. But if it's a yes, that's extremely important because the insurance company needs to know whether or not they need to pay benefits.
Sure.
And failure to timely pay benefits can result in penalties for the insurer, which they don't like. Now, the penalties, as far as I understand it, are paid by the adjuster because typically it's an insurance company mistake as opposed to the employer's mistake. But the insurers, to my understanding, kind of keep track of when the errors are caused by omissions by the employer, and that kind of, they keep internal records of that. So you want to be sure that you're always providing them with the most accurate information so they don't get stuck, footing the bill for something.
I got a follow-up question on that one.
Please.
So hypothetically, let's say Joe Smith twists his ankle. Our EMTs come out there, not enough. We have to go see a doctor. The doctor says, hey, you can't stand longer than an hour, but the insured can accommodate modified duty. What do we mark, yes or no, on that?
You would mark that he is able to work. So you would still mark no.
Okay.
Because this question is concerned about whether or not essentially he's being paid for work.
Okay,
not.
so even if they're doing salary continuation and the guy's not working at all, still be no.
No. If he isn't working at all, then you would check yes, because even though he's receiving wages, there's another box where that's addressed.
Got it.
Yeah.
Oh, there you go. Number 16.
Exactly. You're just getting ahead, John.
Yeah, we're on it.
So you got the last day worked. That would be September 1st, 2020, assuming not able to return. If there was maybe, let's say there's only a week off, if they just needed Monday through Friday, make a full recovery return, then fine, you put the date return to work. But let's in this scenario assume that they're still off of work because of the nature of the injury we're just going to describe. So fine, you check the box for 14. 15, this is important. Did you pay them that full day of wages because they got injured? If they got injured at 8 a.m. After, they started at 7, they're injured at 8, did you pay them that full day? Because anything that's lost because of their injury, they would be entitled to payment from the insurance company. So we just want to make sure that there's no duplication. That's really what I'm going to stress today is why filling out this form correctly and also providing accurate wage records will help keep your premiums down by ensuring we don't double pay.
That makes sense.
Salary being continued, like you said, John, that's 16. So 95% of employers don't have a salary continuation plan.
Yep.
But every so often you find an employer where they want to do right by their employees and they just continue benefits until they know the insurance company is paying. That's fantastic. But I can't tell you how many times I have an employer that wants to do right by their employees, and then I don't find out until 3 months into the claim that they're still paying wages, but the insurance company who didn't know that has also been paying.
How's that work?
A miscommunication.
No. I mean, how's that work in regards to if they've collect wages? I know the insurance company can go back and try to get that money back from the employee, right?
Yes.
Does that ever work out?
Okay, so essentially, the defense can and should pursue a credit for any overpayment that is made on a claim. However, unfortunately, it's not an automatic dollar for dollar credit where all I need to do is prove it and then I get my money back. The law is much more complicated than that in favor of the injured worker. Because presumably maybe this individual collected money that they shouldn't have, but let's say they don't have a lot of money, they don't have a lot of assets, and the value of their claim is super small. So maybe their permanent disability is only going to be worth approximately $2,000, but suddenly we're dealing with an overpayment of $7,000, and this guy's like, I have no way to pay this money back.
Yeah.
So the judge is going to be looking at a lot of different factors, which includes how much of a burden would it be on the injured worker to pay it back? And one of the prime facts is, why was this overpayment caused? Was it caused by misrepresentation by the employee? Because I have those. I have the injured workers like, oh yeah, I'm super injured. Doctor took me off of work, started issuing my payments. Fantastic. The insurance company starts issuing payments. We send out an investigator, do some sub rosa of the guy, which is just surveillance from legal places where you're allowed to observe the applicant. Oh, lo and behold, this guy's going to a job site and he's been working under the table for the last 3 weeks while also collecting a check.
Sure.
So how can the insurance company have known that he's working when he's outright lying? That's a slam dunk on an overpayment.
I've never heard you use the phrase slam dunk.
It's very rare.
I like it.
Very rare.
I love it. That's awesome.
Although I actually should still note that you have to prove how much he received, which makes it more complicated.
Sure.
But it's going to be much. Yeah.
Okay, I got you.
Yeah, a solid alley-oop, as long as you got somebody ranting out at the job site how much the guy was being paid.
That's awesome.
But in a situation where the overpayment is caused entirely for reasons unrelated to anything that your worker did, the judge is much less likely to want to, and use this word loosely, punish the injured worker for something that he wasn't involved with.
Sure.
So it's extremely important that you communicate with your insurance company if you want to be benevolent and continue to make payments. And one of the reasons you might want to do that is because very often the salary continuation is at max wages, and that's an agreement that maybe the employer has with their employees, whereas the temporary total disability rate is only 2/3 of your wages. So there are people where, the employer's like, I know that you have 3 kids at home and you have a bunch of bills to pay and you were performing a job on the site, so I want to do something nice for you. Or for most businesses, I'm very sorry, I want to make sure you get taken care of, but I can't afford to pay you out of pocket. So this is what insurance is for.
So typically that's what we do. So when we have an injury come in, we're getting all the pertinent information like name, date of birth. Obviously, can we ask some questions for HIPAA? But then we run the occupational disability guidelines. And what this is going to show us is where we think this claim is going to go. And that's going to dictate whether the employer should be accommodating modified duty, if we should set them up with a local nonprofit where they can act as a greeter, folding socks or something like that, into our return to work program, or just do salary continuation. Because again, sometimes if you have someone break their leg and your primary threshold's $15,000 and this is going to require surgery, we know the medical cost is going to go over that primary. And so is there any problem with, for some folks continuing to accommodate for modified duty and then for others not?
No. I mean, the question of whether or not accommodator duty is available is something that should strictly be determined on an employer level basis. Okay. And anytime you have the ability to keep an employee working, but I want to caution within the job restrictions that are being recommended by a doctor, assuming that's being met, you should definitely keep them working. Yeah. For both financial reasons to keep claim costs low, and then also from practical reasons. Just because we know that when the body becomes idle, it's just if you don't use it, you lose it.
Atrophy.
Yeah. Atrophy.
So 100%. That's one of the things that we do though. So if that claim, we know their medical costs going over their primary, we always recommend that they let the insurance company pay out those disability payments 100% of the time. And the reason being is those are already lost dollars in regards to a max claim, just on the medical alone. So I was wondering, what you answered perfectly is, can we do it case by case for every single employee and kind of determine that?
Yeah.
Super cool.
It's it's definitely, and I can say from experience, having worked with you guys, is that you guys really assist with that coordination on making sure that a modified return to work offer is available by communicating with the employer. And if it's not, fantastic. Get them out of a nonprofit, get them working, used to waking up every day and going to a job as opposed to staying at home and collecting a check, because it's, for the people that want to continue to feel productive, it's great for them because, most people don't want to sit at home. And then for the people that do, they know that they're just not going to be able to collect an easy, an easy payday on the company dime.
Yep.
So that's definitely a good thing. On 19, the body parts that are injured, simply ask your employee and see what happened. Also do your own investigation and just write down what the body parts that are at issue. this is an area that's definitely important and that we want to know. But for example, let's say the guy is lifting a bathtub and he injures his back. So right away, you're going to put, okay, it's a back claim. If later on that day, when he's going to be evaluated by a doctor, the doctor says, okay, well, you're lifting the bathtub and you injured your back, but it also looks like when you drop the bathtub, you have a contusion on your knee, so there's a right knee involved, and, I'm seeing some bruising on your right shoulder from when you fell backward against the wall, etc. It's okay if you don't have every body part listed here. It's just more a matter of we're trying to get an idea of what the body parts that at least the employer believes are subject to this claim, so we can perform our own investigation. You're going to put the location where it occurred. Usually it's going to be at the same place where the business is, but in this case, this taco truck was located in Canoga Park. Well, it's really important for me to know that, because what if on May 1st, 2020, the employer's like, yeah, but on that day, that taco truck wasn't in Canoga Park. That taco truck was actually across town over in Boyle Heights, serving at a shelter. Who knows? But the point is, it's definitely important to know those kind of facts of where did it actually allegedly occur. So let's go down to 24. Once again, this is, to the extent that you're able, please put this information. It doesn't need to be a 10-page dissertation on exactly what the machinery that the applicant was using and how everything occurred. Something as simple as this individual was ladling some hot oil. That's fine. So they're using a griddle. The griddle had some oil that splashed on them. There's a hot oil ladle involved. Very simple stuff. It doesn't need to be a dissertation. Same thing for the specific activity the employer was engaged in. This form, you don't need to, kind of go all out and explain your whole side of the story. Just give a basic information on what happened. That's where we're going to 26. Once again, if you see, I didn't get crazy with this. It's just while ladling hot oil, looks like a coworker bumped into this person, and that caused the injured worker to ladle themselves with hot oil. 27. Did you send them out for medical treatment? Of course, if it's a whiteboard claim, you guys are going to call it in, and then maybe there's going to be an EMT. And if the EMT can't take care of it and believes that something higher is required, fantastic. Just let us know where they went.
Sure.
So that way we can be sure to contact them, see if there are work restrictions available, which of course I know you guys are already kind of on top of. But also, sometimes these clinics will be able to get us the doctor's first report right away and just cut down on lead time, which is extremely important. Fill in the employee's name, social security number if you have it, their home address. This is all important because we may need to contact them. Their occupation, this is important, and I ask that more time be spent on this than one may think. You could just put, for example, cook. And most cooks are kind of classified similarly. But let's say you have an individual who's a machinist. If you just put machinist, the job occupation codes for machinist ranges all the way from essentially someone doing jewelry and fine manipulation and something that's very minor, which can affect how much their claim is worth depending on what body part is injured, versus somebody who's doing heavy metal pressing.
Sure.
And that's going to make a big difference.
That's good to know.
Yeah, please
Be specific.
Yeah, exactly. And then the date of hire. I really, really want to know this information, just for obvious reasons. One, an employee who's been somewhere for 20 years versus an employee who's been there for 2 days, it typically lends a little credibility to them, if they've been a long-term employee. Additionally, I want to know if they're claiming that they've been working for 15 years, and then suddenly you show me their date of hire is only 4 years back. Like, fantastic. Now I know that they lie about everything.
Yeah.
And this is something that I'm going to come back to. So please put the date of hire. Now, 37 and 38 is arguably the whole reason I wanted to talk about this. It's really why we're here today.
Sure.
Because 37 and 38 seems so simple and straightforward. And if you notice here, I've given an example that Miss Jessica Burns is working a full 40-hour week because that's what she was hired to do. When she filled out her application, we agreed that you would be available to work a 40-hour shift if available. However, how many employers do you have? How many employees do you have that don't actually work a full 40-hour week?
All of them. Yeah, every single one.
Sorry, I meant show up at the
exactly.
workplace. But, you know, it's just, for example, let's say you're working at a factory. Well, what if you don't have enough work that day and you send the workers home early, or they have to check out because their kid is sick and they needed to take the kid to the doctor, so they took an extra 3 hours off of work. All of these kind of nickel and dime scenarios will reduce the number of hours per week that the injured worker actually ended up working. So the reason it's so relevant is because the insurance company needs to know how much money to pay in temporary total disability benefits, like we talked about, and that is 2/3 of the wage. Now, when I get in a claim from an employer that is fully engaged and on top of it, as you know, when any claim is filed, the insurance company will send you documentation, ask for a whole host of stuff, and a lot of people's eyes just glaze over because it has 10 different things they're asking for, and they want the description of job duties, and they want the wage records, and they want to know everything that happened, and they want personnel file, which goes way back. You should do all those things, really should. But one of the simplest ones to give is those 52 weeks of wages through the date of injury.
Got it.
And the reason for that is because we use an average of that 52 weeks to represent what your weekly rate should be. Because we're essentially trying to say, okay, well, how far back can we look to determine what would be a reasonable wage for this person? Well, it's like, well, a year is a pretty decent spot to choose to say, okay, well, we're just going to average your wages across a year and then say however much you earned across that average weekly wage, we're going to pay you 2/3 of that.
Got it. So the problem, I guess, comes up when, let's say someone's been working for 5 years. Over the past 52 weeks, they've gotten, let's say 3 months ago, they went from $15 an hour to $18 an hour. But that was just in the past, few months.
Yeah, that's like it's super important that we have those wage records and also that personnel file, because that personnel file will likely have some sort of performance review and a notation that the person now has a permanent salary increase. So let's say in this scenario that there's no raise, and we look at the 52 weeks of wage records and we find out that she hasn't worked an average of 40-hour weeks. In fact, she's only worked 33 and a half. So that means her wages, instead of being an average of $600 per week, will now be $502.50 per week, which makes a big difference, as I'll explain in a second. But conversely, if in the last year there has been a wage increase that is reasonably expected to have continued had the worker not been injured, then the law is essentially that you use equitable standards. So you say, okay, even if, let's say, Jessica was previously being paid, let's say $14 an hour, and then on August 31st, her boss is like, Jessica, you're doing fantastic. We love your work. You're killing it out there. We're going to give you a whole dollar increase. Then arguably, we would take her average hours worked over that 52 weeks, and then I would multiply it by her new wage, because there's an expectation that that wage would have remained at that higher level throughout the entire year. But if I had just been sent, let's say, just somebody sent me a little printout that said 36,000 hours over the last 52 weeks, I wouldn't be able to parse out that level of information about how many hours they worked.
And that would be very pertinent information to figure out what you guys are going to do.
Exactly.
Okay.
And just by way of example, in California for newer claims, you can get a total of up to 2 years of temporary total disability benefits. Now, in a scenario, and this happens very often, is I get in a claim, the employer is essentially totally checked out, and the insurance company sees this employer's description, and they say, okay, 8 hours per day, 5 days per week, 40 hours a week, $15. All right, average weekly wage is $600. And as an insurance company, you're like, okay, I'm also under the gun because I don't want to pay penalties, and I need to start paying benefits because I know this guy isn't working. Well, the employer's responding to my phone calls, not responding to my emails. All right, I guess I'm going to start paying them at $400 a week just because I don't have anything to say otherwise.
Sure.
And as we already talked about, even if on the back end you find out that, the wages were actually lower, I should have been paying at only $335 per week, not $400 per week, getting that money back is Not impossible.
Can you adjust
Midway,
with new information?
yes.
Okay.
Exactly. So the insurance company will essentially send out a new notice and say, look, moving forward, we're paying at this corrected rate, and we are asserting an overpayment.
They give the justification for that in that letter, right?
Exactly.
So the employee's not like, well, my payments are getting lowered. Why is that happening?
Yeah,
okay.
no, better late than never. But, we're talking, if 104 weeks of benefits end up getting paid out, I mean, the difference from just 7 hours a week out of a 40-hour week can be $10,000.
Substantial.
It can be a ton of money that affects your X mod. So it's really important you provide those wage records. And that kind of brings me to the.
I have one more question on that.
No.
Okay, let's move on. What about bonuses? I know a lot of companies do that, and not all of them are in cash, but some of them are. And how's that work?
That's actually a really good question, and it's once again, it's kind of a case by case, but we're looking at the expectation on behalf of the employee and whether or not this is a single time one-shot merit bonus, or if there is, let's say, a yearly Christmas bonus. Then if there's a yearly Christmas bonus and it's generally around the same amount of money, then a judge would look at that and be like, well, there's a reasonable expectation that, every year this Christmas bonus is going to be received, so that should be considered in the wage. On the flip side, let's say you have, let's say Jessica sold her 10,000th taco, and then they have this whole thing where, hey, when you sell your 10,000th taco, we give you $10,000. Come on down.
Yeah.
So if they do that, well, that's a one-time thing. She's never gonna sell 10,000 tacos for the first time again. So that would not be properly considered as part of her wages. But for that reason, please provide the entirety of everything paid during that 52-week period, and then at the same time communicate. And let us know, for example, if, hey, by the way, because sometimes maybe there's actually a cash advance. Maybe the injured worker wants to go down to Best Buy and pick up a TV, and it's like, hey, I just need, can I just get $4,000? There's this, OLED I need.
Jeez.
They're actually cheaper now.
Yeah,
I overpaid.
$4,000 for a TV. That's nonsense.
Who cares that his kid needs braces?
Yeah,
but
exactly.
the game's on, man.
Yeah, have to.
Yeah, but that advance might look like a bonus, or I may not know what that advance is. So please definitely communicate.
So are you getting a lot of
payments.
employers that just are not communicating with you on this stuff? Is that common?
Too many.
Wow, that's frustrating. That's frustrating to hear, because that is something that we talk to all of our clients about, and how important it is to keep these type of records, to communicate nonstop with your adjuster and your attorney defending you. You have to give them the tools so they can do their job.
Yeah,
that's wild.
Yeah, it's it's just one of those things where if employers are looking for where they can have the most impact, they can have the most impact on providing the information that only they have.
Got it.
No matter what I do and what the insurance company does, they'll never know what you, the employer, know.
Understood.
Yeah. Which brings me to the second aspect of, once again, this employer exclusive knowledge that we really need. And it can be kind of daunting. So I have in front of us, once again, this is a form provided by the state from the Department of Industrial Relations, Divisions of Workers' Compensation. And this is the description of employee job duties. Now, John, how many times have you had an employee in your experience accurately reflect what their job duties were when talking to somebody else?
Like one of my employees?
Yeah.
Pretty accurately. Yeah, everybody knows what they're doing around here.
That's good. You have trust.
Yeah, 100%.
Well,
maybe not all their extracurriculars, but yeah, in regards to what they do on a day-to-day basis, we got our finger on the pulse on that.
Well, that's good. Then this, maybe wouldn't be as scary for you. But for, in my personal experience, you have employees that overstate their job duties and how strenuous their job duties are for two reasons. One, it could just be, some people are really genuinely bad at gauging things and estimating weights.
Most people are, yeah.
Estimating how long they do things throughout the course of their day. And what happens is they are going to doctors. They're going to their treating physician, and eventually they're going to the qualified medical examiner in many cases, which is the state-assigned physician. Maybe they'll go to an agreed medical examiner. But the point is, the doctors are making opinions, especially for cumulative trauma claims, based on what the job duties are. So the question is, okay, Miss Jessica Burns, you're claiming that you injured your back on a cumulative trauma basis. Well, I'm looking at your description of employee job duties, and it looks like you flip tacos. And the heaviest thing that you're lifting is a bag of tortillas weighing 5 pounds. So how are you getting a lumbar strain if your job doesn't involve anything that would logically lead to that? Now, in that scenario, the only reason that the doctor was able to accurately give that opinion was because the employer filled out this form. And if the employer hadn't filled out that form, Jessica would have been like, but I'm responsible for all the restocking. And I'm the one who has to go to, the supply store, and I'm lifting 60-pound bags of charcoal, or, I'm the one lifting the propane tanks, and I'm the one changing them out. And then suddenly the employer's like, hey, why is this back injury accepted? It's like, she never lifts the propane tanks. It's like, well, we didn't know that.
Sure.
And we have nothing to rebut it. And the insurance company sent you this form and nobody filled it out. So how are we supposed to know if she's lying or not about what her job duties were? So once again, a daunting, long form. But if you just go through it step by step, it's relatively straightforward stuff. And all you're doing is advising the frequency that they're engaging in all these very specific job actions.
When you're talking about these forms and the tediousness of them, it's important to know that this is 10 to 15 minutes of work that could cost you, done incorrectly, $10,000 to $20,000 in premium.
Easy.
And that's terrifying that employers don't know that.
Easy. It's,
I guess, why would they? Like, no one's instructed. Yeah, that's, like, they'll take care of it.
Yeah. That's why I got insurance. Or, how many emails do you get a day? How many phone calls do you get? Like, we're busy. If you're running a business, the last thing you have time for is to fill something out like this form. But like you said, it's 15 minutes now, or 20 grand later.
Yeah, you got to put the metrics on it. And if you don't put that on there, like, it's a form. But if you actually know how much this form done incorrectly can cost you, at that point, we're in a different ballgame.
Yeah, and, I'm an attorney. I can't do math for, to save my life, but I don't know what 15 minutes for 20 grand is, but that's a pretty decent return.
That's awesome. You're like a tenth of Elon Musk's salary right now.
Yeah, I'm just looking at the camera, man. Like, hey, can you just do quick math? Can you just spit out that figure? But so actually what I brought here today is a sample that I took from one of the employers that I have. And this was an interesting one because we were actually disputing whether or not the modified duties were being honored correctly. So the injured worker, he was working at a lumber yard, and he was provided with modified duties. And he said that essentially the employer wasn't honoring anything, and he was working almost his full duties, which included lifting up to 100 pounds, doing a lot of power grasping and lifting heavy things, holding machinery in place, very strenuous activity. So I reached out to Brady, actually, and Brady got in touch with the employer on this case. And between the two of them, they had this thing back to me in 48 hours. It was fantastic. And as you can see, looks like the heaviest thing this guy's lifting is 25 pounds. Now, the difference between 100 pounds and 25 pounds is virtually night and day. He says that he's carrying these heavy planks of wood all across the lumber yard. Well, according to the employer, he's only carrying about, he's not carrying them at all because he's working at a single station, essentially never takes anything away from a station. And she actually went out of her way and got an employee who was nice enough to not complain and who brings him all of his stuff. So everybody else has to go and get all of their materials, and he gets somebody to cater to bring it all the way to him just to be sure that he doesn't act outside of his job duties.
So how's that work? So if someone is acting outside their scope of their modified duty, write them up for sure, right? But how's that work if they get injured going outside their scope of their modified duty?
It can, one, if the injured worker is acting outside of their job duties, as a preliminary matter on a baseline, that is AOE COE in that it arose at the workplace and the employer will be responsible for it. Now, for that reason, we definitely don't want you exacerbating, your current injury. So it's counterproductive if you're injured and you're working modified duty, and then the employer's like, yeah, I just need you to do the full job, because then he's just going to get worse.
For sure. And I don't think any of our clients or most employers would be like, oh, this is outside your work restrictions. Doesn't matter. Do it. I don't think that if ever happens.
It's very, very well. I have plenty of injured workers who claim that that's what they instructed, but at the same time, I agree with you. I would say most, if not all, employers would never do something.
I know mostly what happens is these employees will get their work restrictions and then work outside of that on their own.
Yes.
That happens a lot.
And the employers, it's kind of two scenarios. One, very often the employer themselves, the owner, doesn't know, because they're not, they are on the ground watching every employee. So it's really the chain of command of managers and supervisors who just kind of turned a blind eye because they're tired of reminding him. But at the same time, maybe you feel kind of bad. It's like, well, he's allowed to lift up to 25 pounds, and I know that this crate is only 30 pounds. Whatever, he doesn't want to feel singled out, and he doesn't like the way that the other employees are kind of making fun of him, saying that he's weak, etc. So these kind of things do happen, but unless you are actively reprimanding that employee, forbidding them from engaging in the activities that are beyond their job duties at the time, and writing them up, like you said, then you're going to be responsible for it. But
Sure.
if an injured worker continues to violate your instructions, I mean, at a certain point, actually,
Constructive discharge.
That's disobedience, and it's causing a potential liability for the workplace. So that's really problematic. But it's just, you can't sweep it under the rug.
Yeah, just an anecdote on that. I was in one of our clients' restaurants, Sidewalk Cafe, and they had one of their employees, and the GM was in there, the owner was in there, the CFO was in there, and we just like, well, I forget her name, doesn't matter. She's lifting this stuff. And they're like, well, what do we do? And it was very funny. I was in there. It's like right when we brought him on as a client, I was like, you write her up. For sure. She's acting outside. Like, this is what you have to do. And they're like, oh, and they did it right on the spot, which is a great practice to have. Because if constructive discharge happens, indemnity payments are no longer entitled to that.
Well, I mean, look, if they're terminated and we have a viable post-termination defense, that may prevent them from having any eligibility. Now, if they're doing that heavy lifting and then they get injured, before it reaches the level of being so gross and over the top, then any time an injured worker is injured while, and this is not the legal standard, but for practical purposes, if there's benefit being provided, and it's within the scope of their employee, their job duties reasonably, like it's going to be compensable.
Yeah, that makes sense.
Yeah, but once again, that's not the legal standard. So
yeah,
it's much more complicated. But yeah, so that's basically just the two things that I really wanted to go through today is once you go through them, it's not as scary as it looks, like you said. It's about 15 minutes. But the last thing I do want to mention about this description of employee job duties is, from a practical standpoint, the way this is going to work is the injured worker is making representations in deposition. They're telling the doctors in the case about what their job duties are. Ultimately, all I as a defense attorney can do is essentially provide this as rebuttable evidence, because the odds of taking an employer deposition, very, very rare in a case. So essentially what's going to happen then most of the time is both of these things are going to go to the physicians in the case, and the doctors are going to have to issue a either or opinion. So they're going to say, okay, assuming the employee is correct and this is their job duties, this is what the case would be. These are the body parts that would have reasonably been injured. Conversely, if the trier of fact, which is the judge, finds that the employer is correct and that these are their job duties, then this would be what the proper injury should be. This is how much money they should get, etc. Then we're going to go to trial, and in trial, it's going to be a straight credibility check. So it's going to be the injured worker on the stand testifying, and then on the flip side, this form is not going to be enough. I'm going to need the person who filled out that form to actually come down and describe competently to the judge, to their standard, that no, the injured worker is lying, and that in fact these are the job duties. So what I want to put a caveat on is sometimes I'll get these from, let's say, the CEO of the company, from his belief of what he hired this guy to do.
Sure.
But the CEO won't be able to testify to what his job duties were unless the CEO is actively there.
So you
day
need that
in, day
manager
out.
in there.
Exactly. Rope in your manager. If the manager needs assistance filling out the form, maybe there's a language barrier, this thing is available in Spanish. If they speak a different language, you can rope in a translator, somebody from the office, but it doesn't need to be something scary. It's just a matter of they need to be able on the backside when we go to trial to competently testify why, let's say, that there's no power grasping involved in the job, and that, all he's doing is using a machine that does all of the heavy gripping, and all he's doing is, punching keys on a very fancy piece of machinery.
Sure. I want to circle back
Sure.
on the initial one, we talk about the job duties. And what if someone is, let's say they got injured recently, but 3 months ago, their job duties changed from just for a landscaper, like a day laborer, to more of a supervisory position. How does that work?
Super glad you asked, because that is a very, very often occurrence. In any course of employment is, presumably if you're keeping an employee and he's getting better and better at his job, then typically they're going to rise up the ranks. But that also means that their actual job duties are changing. So when that happens, the thing that I always recommend is that 2 separate description of job duties be filled out. And just let me know from when to when that worker was working these duties, and then when they switched. Because, for example, let's say it's even a specific injury, and the guy is saying, oh yeah, on September 1st, 2020, I was using the drill press, and I put a hole through my hand. And it's like, okay, well, for the last 3 years, you've been a supervisor, and I know for a fact that you're not supposed to go near the drill presses, and that you haven't gone near a drill press. And we do an investigation. Turns out it's because he was trying to make a fancy piece of wood for his girlfriend.
Sure.
It's like, okay, well, if I just look at a description of job duties and it's from when he was hired, because you're just kind of include that in the personnel file, I'm going to look at that personnel file and go, okay, well, yeah, let's see. He's a lumber handler and he's doing a lot of fancy woodworking, so it makes sense he's going to put a hole in his hand. But then conversely, it's suddenly, oh, I have the one from when he was hired, and then it looks like 2 years earlier, now he's a supervisor, and that would never enter into his job duties. Okay, now there's some real questions here.
Got it. That's super important information.
Yeah.
Awesome. Did we cover everything?
I figure your employers are already, their heads are spinning. They're all reaching for a bottle of something.
Yeah, absolutely.
I just want to say that the new legislation explicitly references that the relevant facts include the efforts that an employer is taking to prevent COVID. So for all the employers out there that are putting up the signs about wearing masks, putting up signs about where people should stand and where the 6 feet are, all of them, offering PPP, spending all that money, buying plastic shields. It is not in vain. The legislature has finally heard you, and we will be able to take this into account in future COVID legislation. So don't give up hope, and awesome. Please double down on safety. That's
great. So if you can demonstrably show that you've actually done a good job preventing COVID, that's going to go into your case. That's great. Yeah. That's awesome news.
And then, like I said, it's like, okay, fantastic. Well, if the employer's doing all these things, and then we know that you play in a baseball league on the weekends that's still actually running, even though you're not supposed to, underground at a park, like, I think we know how we got it.
Sure. That's awesome. Lior, thank you so much, man. I really appreciate your time and coming in here, and we'll see what happens after September 30th. We'll have you back.
Absolutely.
Awesome. Thanks for listening, guys. Have a great week. Adios.